Hello, class. Welcome to American National Government Political Science 200. Today is our first day of doing things online. So good luck, class. We'll try to get through this together. Today we will be studying the judiciary. The judiciary. So, first thing we're going to look at is the scope of judicial power. How powerful is the judicial branch? What powers do they have? What powers do they not have? That type of thing. So the first thing to consider is that the American judicial process rests on an adversary system. A judicial system in which the court of law is a neutral arena where two parties argue their differences. Right? So according to this legal approach, this legal model, this legal method, how much power does the judicial branch have? Michael? I'll read again. The American judicial process rests on an adversary system, a judicial system in which the court of law is a neutral arena where two parties argue their differences. Okay. So according to this idea, how much power does the judicial branch have?
That meaning a lot.
If something is neutral, how much power does it have?
Oh, none, I guess.
None! Exactly! And so that's the thing. Some countries do not have this type of system. They have a system where the judicial branch can issue advisory opinions. They can do other things, but they're not supposed to be neutral where two parties duke it out. So if you follow this model through to its logical conclusion, in theory, the judicial branch has very little power, right? It just makes sure both sides are playing by the rules. This is illustrated by the Chief Justice of the Supreme Court right now, John Roberts, when he was asked, what is the judicial role? And he answered, it's the judiciary's responsibility to call balls and strikes. We are like an umpire at a baseball game, calling balls and strikes, and nobody ever went to the game to see the umpire.
So how does it work in other countries?
Well, see, that's the thing. In other countries, they're not always so neutral. They aren't just a neutral arena where one side dukes it out. They're allowed to issue advisory opinions and things like that. So, got it? Now, in practice, especially the Supreme Court does exercise a lot of power because it's a court of last resort and it's not just calling balls and strikes, even though that's what John Roberts says. Their own approach to the Constitution will influence the way they rule.
Well, typically when the founders started it, didn't they want all three branches to be equal?
Yeah, but they knew the judicial branch would be the weakest of the three. That's why in the Federalist Papers they called it the least dangerous branch. And again, I told my class this, if you look at how long the Constitution is when it describes Congress, it's this long. It's half as long again to describe the presidency, and it's that long to describe the judicial branch.
So they didn't plan on all three being equal?
Well, the exact phrase they used was the least dangerous branch. Yeah, a lot of the time people say, all three are equal. Not really. I mean, the founders didn't envision it that way. Equal in what sense? You know what I mean? So the point is, they obviously thought at the time of the founding Congress would be the most powerful. That's why they divided it into two chambers, right? And the executive less powerful than that, and the judiciary even less powerful, right? But they had ways of making sure that the other branches did not get too powerful, right? So when we say all equal, I think you have to be careful using that expression, right? Because no, the judiciary was not meant to be as proactive as Congress. Good question, Nancy. It's a Canadian asking that question. So, okay. So everyone got it. The role and vision for the judiciary was fairly small, but the judiciary has grown in power significantly since the time of the founding. That's a good question. Okay. So, next thing, judges decide only justiciable disputes. You know, I'm going to write that down because it's not a term that we use a lot. Justiciable disputes. You can always pause this if you want to take additional notes. Okay, so what's a justiciable dispute? That's a dispute growing out of an actual case or controversy and that is capable of settlement by legal methods. Okay? Now, a lot of debate has occurred around what is a justiciable dispute and what is not, right? So let me give you an example. According to the U.S. Constitution, which branch has the power to declare war? Congress. Very good. Congress has the power to declare war, right? So did we go into Afghanistan militarily without a declaration of war?
I believe so.
Yes, we did. Absolutely. Right. So, say I thought my tax dollars were being used unconstitutionally, right, to support a war where there was no declaration of war. We just had military action, and the president went in with guns blazing and huge public support, right? Okay. So, say I file a lawsuit, right? And say, hey, my tax dollars are being used unconstitutionally, right? It'll go to the court system. It may even reach the Supreme Court, and the Supreme Court will say whether or not we go to war is not a justiciable dispute. It's a political question, not a legal question. If you don't like the fact that we went to war, and if you think we went to war unconstitutionally, then you should vote your elected officials out of office. But don't file a lawsuit. That's a political question, not a legal question. So run for office yourself, build public support against the war, and say, let's vote the bombs out, but don't file a lawsuit. Whether or not we go to war is a political question, not a legal question. Any questions on that? Okay. Now, to muddy the waters, let me tell you about a case. You don't need to know this unless you take my con law class, in which case you will have to know this. It's called Waltz versus Tax Commission of the City of New York. And a guy named Waltz didn't like the fact that churches had tax-exempt status, right? So, because churches are tax-exempt, do they get a lot of public services at public expense? Police protection, fire protection, roads, water, other utilities. Do they get a lot of those at public expense?
Yes.
Yes, absolutely. So if churches are not paying their fair share, then does that mean that you, as a public citizen, such as Waltz, need to pay more?
Yes.
Yes. So, does the Constitution say Congress shall make no law respecting an establishment of religion?
Yes.
Yes. So, if they pass a law that allows religions, but not people, to be tax exempt, is that a law respecting an establishment of religion?
Yes.
Yeah.
Are his tax dollars being used unconstitutionally?
Sure. Yes.
Yeah. That's what he claimed, right? So, his case went to the Supreme Court. And this time, interestingly enough, even though to me the argument is the same, my tax dollars are being used unconstitutionally, this time the Supreme Court took the case. And they said, oh, churches are allowed to enjoy tax exempt status because if they had to pay taxes, it would lead to an excessive government entanglement with religion. Right? So they said it actually helps maintain the separation of church and state. Right? But for our purposes here, what's interesting is that the legal arguments were very similar. My tax dollars are being used unconstitutionally. If you try to file a lawsuit saying any military action is your tax dollars being used unconstitutionally unless there's a declaration of war, what will the courts do to your case?
Turn it down. They won't even take it.
Turn it down. They won't even take it. Exactly. If you're Waltz, did the court take the case?
Nope. Oh, yes. Sorry.
Yes. In Waltz, they definitely took the case. So, why'd they accept the one but not the other? Why'd they say this is a justiciable dispute, this one is not? When both were dealing with whether or not my tax dollars are being used constitutionally or unconstitutionally. Why'd they take the one, not the other? Throw out ideas. No wrong answers here.
I don't know, it just felt like it.
It just felt like... Okay, number one. Does the court have a history of deferring to the military?
Yeah.
Yes. They don't even want to touch the decision whether or not we go to war, whether that's constitutional or not. They have a history of deferring to the military. They have a history of deferring to the president when he is acting in his role as commander-in-chief. They're not touching that sucker. Right? Why'd they take the religion one? Well, I think in ways because they kind of had to. Right? I mean, if churches lost their tax-exempt status, what would happen to churches all across the United States?
They'd probably fold.
They'd go under. Absolutely. Right? Because they have to pay property taxes each year, and they're already operating on really tight budgets a lot of the time. A lot of churches. So, after our brief discussion, I gave you only 2 cases. Who decides whether a case is justiciable or not?
The court.
The court. Exactly. Right? And so, in terms of our discussion, how much power do the courts have? It all depends how they want to play it. They took Waltz. They're not taking any cases dealing with the constitutionality of whether or not we go to war. So it's up to the courts. The courts have a lot of discretion. Right? Okay, which brings us to the next point. The party bringing the lawsuit, the plaintiff, must have standing to sue. Standing. Plaintiffs must have sustained or be in immediate danger of sustaining a direct and personal injury. Okay? So, we've discussed this before, but we'll touch on it again in this context. Griswold versus Connecticut, 1965. Okay. Griswold versus Connecticut, 1965. Now, before this case reached the Supreme Court, let's go back in time a little bit. There was a law on the books in Connecticut outlawing contraceptive use, right? Can't use contraceptions. And it was passed back in the late 1800s, right? When contraception was not nearly as good as it is today, right? Also, the law was motivated a lot by people's religious beliefs, felt that contraceptive use was wrong, right? And back in the late 1800s, they thought, good law, right? Okay, well, decades pass, contraception becomes much more common, acceptable, and safe. And it was widely available in basically any and every drugstore in Connecticut, right? So, some people wanted to challenge the law. They said there's no rational basis for this law. Why can't people use contraception? It's their individual decision, right? So they challenged the law, and the first time it reached the Supreme Court said, who's been arrested? And the people wanted to challenge the law said, well, no one. And the court said, who's been fined? And the people wanted to challenge the law said, no one. And they said, who's in danger of being arrested or fined? And they said, well, no one really. It's not being enforced. And they said, is contraception widely available in the state? And they said, yeah. Is anybody getting prosecuted for using it? No. Then get out of our courtroom. You don't have standing to sue. The law's not being enforced. You're in no danger of being harmed. You have not been harmed. So you don't have standing to sue. You don't have standing, right? So the people who want to challenge the law were frustrated. So they said, well, if we have to get arrested or fined, then we will get arrested or fined. So they opened a Planned Parenthood clinic, basically held a press conference, basically invited the cops. We're going to be prescribing contraception in violation of this law. Arrest us. And so they were fined or arrested. I don't know which one, but it was, small fee or small arrest, whatever it was. Now the case went up, and now do they have standing to sue?
Yes.
Yes, they do. Absolutely, right? But it wasn't until they went through that whole process that they had standing to sue, right? This is one of the reasons why conservatives hate this case, because conservatives see it as being artificially manufactured, right? They're like, no one was being harmed by the law. There are lots of stupid laws on the books, right? So should have just left it alone, let it go. And Griswold versus Connecticut leads to the right to privacy. That was the famous case where the court said you had a right to privacy. Griswold versus Connecticut then leads to Roe versus Wade, 1973, where the court says your right to privacy is sufficiently large to encompass a woman's decision whether or not to terminate her pregnancy. So Griswold versus Connecticut leads directly to Roe versus Wade. And that's why conservatives, one of the reasons why conservatives have such a problem with Roe versus Wade was because it goes back to Griswold versus Connecticut, which conservatives see as a very contrived case. Conservatives would have said, if you didn't like the law that was on the books, then you should have tried to change the law within the legislative process, not the judicial process. So this goes back to our discussion, the scope of judicial power. Well, there it is. The court the first time said, you don't have standing to sue. This law isn't even being enforced. And when Estelle Griswold opened her Planned Parenthood clinic, maybe the cops shouldn't have enforced the law in that situation either, and life would have just gone on. Any questions on that? Nope. All right. Now, again, since we're under no time constraints, we're all on lockdown, and we can discuss things a little more. Standing to sue. Say the Environmental Protection Agency, right now, say the Environmental Protection Agency is not enforcing environmental laws as rigorously as they did in previous administrations. Say the Obama administration, right? And I am someone who is very frustrated and concerned about that, right? I'm like, the air is not as clean, the water is not as clean, the EPA is supposed to enforce these regulations. They are not, right? So, have I been harmed?
Yes.
Yeah. Okay, yeah. So I'm filed a lawsuit, and right now the case will go to the Supreme Court, and under John Roberts, what do you think the court is saying when someone says, I'm a citizen who is being harmed because these environmental laws are not being enforced the way they're supposed to be?
I guess they think you're not being harmed if you don't have some medical condition right now.
See? Excellent guess. Yeah, they'll say you're not being harmed any more than any other person, right? So consequently, you don't have standing to sue. And this goes back to what we were talking about earlier. They'll say it's a non-justiciable dispute, right? If you have problems with how these laws are being enforced or not enforced, it's a political question, not a legal question. Should vote the bums out. Don't vote Republican next time in this case. But get out of our courtroom. What do you think about that? Not having standing to sue if environmental laws are not being properly enforced.
I think that's kind of stupid, maybe.
Yeah, See, and that's the thing. It's been a real change with the Roberts Court. They've been less willing to grant standing in these environmental cases, showing kind of how conservative they are. It's 23 minutes? Okay. So, next thing we want to take a look at is a class action suit. That's a lawsuit brought by an individual or a group of people on behalf of all those similarly situated. So, if you've watched any daytime television, you've probably seen attorneys asking if you've been harmed by asbestos, if you have mesothelioma. Is that how you say it? That type of thing, right? And you can join a class action lawsuit, right? Why do you think class action lawsuits exist? What's the logic of class action lawsuits?
Because a big company can just pay off one person. It's no big deal. If it's just one person suing them.
Yeah, right. Well, and also a lot of people have a very similar condition. Right? And so, if you've gotten a certain type of lung cancer because you've been exposed to asbestos, that's going to cost a lot of money to treat, right? And so the idea is, you put everybody in together and then you let the attorney sue and then everyone who's similarly situated gets a settlement, whatever it is, 100,000, 200,000, and then attorneys usually take their commission, right? Which a lot of times is pretty steep, like a third, half type of a thing, right? But say your settlement's 100,000, even if the attorney takes half, what does that leave you with? 50,000. Yeah, 50,000. Exactly, which is good, right? Okay, so the logic of class action lawsuits is pretty sound. The problem is the potential for abuse, right? Do you guys remember A Knight's Tale that we watched at
movie?
Yeah,
Yeah.
with Heath Ledger? Yeah. What did you think of it?
I thought it was kind of silly.
Yeah, kind of so, but it was with Heath Ledger. A lot of people like it. It kind of has a little bit of a cult following because it was a little off. Anyway, when they were marketing A Knight's Tale, they included promotional material that said things like, greatest movie ever, whatever it is, and they quoted people. Those were made up. They just lied on their marketing material. Best movie ever, Michael Travers at Rolling Stone or whatever. They made that up. And so a lawsuit was filed, class action suit, on behalf of everybody who'd seen A Knight's Tale. And case went to the courts, and the court said, you're right. You've been harmed. People were duped into seeing a movie that was subpar that they wouldn't have seen otherwise, right? You're entitled to damages. How much is a movie ticket? Whatever, $10. And so you get half. You get half, your attorney gets half. Well, if an attorney brought the class action lawsuit on behalf of 1 million people,
Oh.
right? How much does he wind up making?
$500,000.
Yeah. How do you figure?
I thought you said $1 million.
1 million people.
Oh, 1 million people.
1 million people. $5 million bucks.
But they each only got 5.
Exactly. And so that's the potential for abuse with class action lawsuits, right? Is they in essence give attorneys an incentive to find these types of situations where a lot of people have been harmed, even if it's in a very small way, because if I'm an attorney and I can file it on behalf of a lot of people, I stand to make a lot of money. So I don't even know how many people collected on their $5, Yeah. Or how you found out about it, but it's just kind of an abuse of the logic of class action lawsuits. When attorneys get that cut. Yeah. Okay. Next, when individuals sue each other over a traffic accident, for instance, they file suits under civil law and seek monetary awards for the injuries they suffered or the damages to their property, right? So the big difference between criminal law and civil law is that in civil law, you cannot go to jail, right? Under criminal law, the potential exists that you can go to jail for a lot of criminal law, right? But under civil law, there's absolutely no risk of going to jail. Zero, right? It's just one individual suing another. And this illustrates really well when the court is actually acting as a neutral party that just decides who's at fault here, right? It's in civil suits. Now, only the government may prosecute individuals accused of crimes such as robbery, as defined in state and federal criminal law. So, if you're ever accused of breaking a law, it will be the government against you. And that's a daunting position to be in. You know, the government, everybody against you. Because who has superior resources? The government does, exactly. So, yeah, that's very intimidating. That's a very daunting position to find yourself in. Okay, now, any question on those? Okay, now, prosecutors decide whether to charge an offense and which offense to charge. Okay, now, let's actually, how are things looking?
I'm just making sure it's still recording.
Yeah, I think we're 30 minutes here. Let's go back to the civil and criminal law. So, O.J. Simpson, big case from a number of decades ago. I was in college when it happened. It's a huge deal, right? O.J. was accused of murdering his ex-wife and her boyfriend. Okay, so they had the criminal case first, charging him with murder. And the standard that needed to be met was beyond a reasonable doubt, right? So that means if you as a juror have any doubt in your mind that O.J. committed the crime, then you're not supposed to vote guilty, right? And so in that case, the police kind of they botched the crime scene, didn't handle the evidence really well a lot of the time, and there was famously a pair of gloves that were found at the crime scene that everyone thought were OJ's, and they were leather gloves, and they'd gotten wet, something like that. You know, like all this stuff is this total scandal, yeah. And he tried to put the gloves on at the trial, and he was like, "Oh, they don't fit. They don't fit." You know? Everyone's like, "Well, the gloves don't fit." Right? And there are a bunch of other things. Anyway, the point is, you know, his defense team did a great job of creating a reasonable doubt in people's minds that he had committed the murder, and so he was acquitted. He was found not guilty. He was let off of the criminal charges, right? But then a civil suit was filed against him on behalf of the two that were murdered, and there the standard is not as high. It is a preponderance of the evidence suggests that the person committed the crime, right? So you look at all the evidence, and does all the evidence suggest the person committed the crime? Yeah, you look at everything, and the overwhelming amount of evidence suggests he committed the crime. So he was found guilty in the civil suit, owed the families money, but he still is not going to jail, and he's free to golf and do whatever else he wants to do. Till he got arrested later for another crime, right? OJ, it hasn't been good for OJ. Okay. So back to the next one. Prosecutors decide whether to charge an offense and which offense to charge. All right. This takes us to my brother-in-law Derek's story. This was a family tragedy, but now that it's over, we can laugh about it. So, right? Yeah, I guess so. But anyway, it was the day before Christmas Eve. My brother-in-law Derek was a third-year law student at Chapman University, doing really well. He was married, had one daughter already. His wife was like 8 months pregnant, about to have their next child. And we had all gotten together as family down there. My father-in-law, my mother-in-law, Derek and his family, and my wife and I and our family. All gotten together down there to spend the day together, spend some time together. And at dusk, my father-in-law said, well, let's have an astronomy lesson. Let's stargaze. My father-in-law is really into stargazing and quite good at it. So he had a laser pointer with him, right? A high-powered laser pointer. And I don't know if you guys have ever seen these, but they're kind of really impressive. You can point them literally at the stars and say, hey, see that star there? That's that one. Well, anyway, it was dusk, and my father-in-law gave it to my brother-in-law, Derek, and said, hey, here's this laser pointer we use for stargazing. And my brother-in-law pointed at a building, pointed at a tree, and there was a helicopter in the distance, and he pointed it at the helicopter. Then he pointed at another couple things, and I think he pointed at the helicopter again. Well, it wound up being a police helicopter. And unbeknownst to us, apparently it interferes with their guidance systems. The way he pointed it, also, it hit the shell of the helicopter and lit it up, so he could not see, or the people in the helicopter could not see anything visually. Their instruments were down, and they were, they were understandably really nervous, really concerned. And also, laser pointers are used on high-power weapons. So they thought maybe they were possibly under attack. So it's not a good situation. Not a good situation. A few minutes later, the helicopter started circling the house like an episode of Cops. And I asked my brother-in-law, what's going on? And he's like, I don't know. This helicopter's been circling the house for a while. And I saw the laser pointer in his hand, and I said, the cops are going to be here in a few minutes. You better get your story ready, because the cops are coming. But I don't think he told me that seriously, because once the cops got there, he didn't have a very good story. But anyway, the cops show up, and they said, who has a laser pointer? And my brother-in-law, Derek, said, I do. And they said, can we see some identification? My brother-in-law gave him his driver's license. And they said, have you ever been arrested, Derek? And that's when I knew it was going to be bad, right? When they asked him if he'd ever been arrested. He said, no. And they said, sit down right over there. And the cops were in their cars. They phoned up to the guys in the helicopter. They explained the situation. It was an honest mistake. He didn't know what he was doing. But the cops in the helicopter were mad. They were mad. And apparently it had been a problem in Southern California with people using laser pointers to target helicopters and law enforcement officers. So the cops said, I'm going to have to take you downtown and arrest you. So they arrested Derek. He had to spend the night in jail. It was not a good experience for him. Then we found out it was a violation of both federal law and state law, right? It was a violation of federal law because he interfered with an aircraft while in operation. It was a violation of a state law because he shined a light in the eyes of an officer while in the line of duty. So, case went to a federal prosecutor. Federal prosecutor gave him a call, said, tell me what happened. Derek explained the story. And the federal prosecutor totally dropped the case, right? Said, don't worry about it. Go on with your life. Don't let me catch you doing something like this again. And that was it. 100% dropped the case, right? Why do you think the federal prosecutor dropped the case?
Because it was an honest mistake.
Honest mistake. Bigger fish to fry. You don't want to go after otherwise law-abiding citizens who made an honest mistake. We all make mistakes. So the prosecutor decided this guy's not a career criminal. He's not going to break the law again. He's 1 semester away from getting his law degree. This is a waste of federal resources to go after this guy. Right? So the federal prosecutor 100% dropped the case. Then the state prosecutor called and said, basically, we're going to bring you up on felony charges. We've had a problem with this type of thing. We're going to make an example of you. Totally different reaction. 100%. You guys know you lived the story, but just 180 degrees different reaction. Could charge it as a felony or a misdemeanor. The prosecutor decided to go with a felony. So he had to get an attorney. They managed to plea bargain it down to a misdemeanor with the understanding that he would plead guilty and have to do a certain amount of community service, but at least he'd be able to sit for the bar, become a barred attorney, and get his life back. So, what do you guys think about that? A prosecutor having that type of discretion?
I mean, I guess that's just the way it is. I mean, it just seems weird that the same crime could have totally different consequences.
Yeah.
For 2 different people.
Do you think it's a prosecutor's decisions ever affected at all by the race,
Definitely, probably. I mean,
wealth,
yeah.
family connections?
Yeah.
And that's one of the concerns, is there's just huge disparities in who prosecutors choose to go after and who they choose not to go after, right? Because prosecutors can just 100% drop the case.
Yeah.
Yeah. Now, and also, they can decide whether, sometimes, depending on the crime, to charge it as a felony or a misdemeanor. Some things are just, by their very nature, misdemeanors. You know, you can't elevate them to a felony. You know, jaywalking, oh, it's a felony. You know, you can't do that.
Yeah.
All right. So, 42 minutes. We got about 8 minutes later. So that takes the plea bargain. It's an agreement between a prosecutor and a defendant that the defendant will plead guilty to a lesser offense to avoid having to stand trial for a more serious offense. And again, one of the huge concerns with our legal system is that prosecuting attorneys, they know that if everything goes to trial, our court system will be backlogged. Like, we'll never make it through all the cases we have to hear. Mm. So they intentionally elevate the charges. You know, I'm going to bring you up on felony charges for this, in the hopes that you'll plead guilty and plea bargain it down to a misdemeanor.
Wow.
I know. Well, that's the concern, right? And that's what happens all the time, is they know they can't have all these jury trials. So we're going to throw the book at you. No, please, just let me off of here. Okay. And then you forfeit your constitutional right to a trial by jury. Yeah, it's wrong. Yeah, but it exists. Okay. Now, to sum a couple things up, just so you guys understand the court structure, federal court structure, I'm not going to write it down. You can, like, say, you can pause this, right? But there's 93 and 94, depending on exactly how they're counted, whether you include DC and blah, blah, blah. but there's about 93, 94 federal district courts. There's 13, 14, again, depending on how you count them. DC's or blah, blah, blah. 13 circuit courts, then the U.S. Supreme Court. So, let's just say 93, 94 district courts, 13, 14 circuit courts, U.S. Supreme Court, right? So you take my brother-in-law Derek's situation, the rogue laser pointer, right? And where would his case go to for the federal charges if he were being prosecuted?
Oh, the lowest.
The lowest, exactly, district. That's where everything starts out, is district courts, right? Then circuit courts, then U.S. Supreme Court, right? And so the circuit courts are what are called appeals courts, right? And so your case is initially handled in district court, and then if you think there was some problem, you weren't adequately represented, you file appeal, it will go to circuit court. And then if you think there's a question of law that was unfair or whatever, then it'll go to U.S. Supreme Court, right?
And if they don't take your case, you're just out of luck. You just go with whatever the circuit court rules. Or...
Correct. Yep. If the U.S. Supreme Court does not take your case, then lower court ruling stands. Also, interesting note, excellent question. That's why we have a class. If your case does go to Supreme Court and it's tied, say one of the justices has recused himself or herself and ends like 4-4, then the lower court ruling stands. Yeah. So circuit court ruling stands. All right. Now, this takes us. We have just one more thing to say here, and that's that state courts primarily interpret and apply their state constitutions and law. Only decisions that raise a federal question involving the application of the Bill of Rights or other federal law are federal courts able to review. Right? So, let's just use the example of gay marriage, because it's just such an outstanding example for so many things. Before 2015, which level of government was responsible for defining marriage? State, exactly, right? So, if I think that state laws banning gay marriage are unconstitutional, then I have to find a federal question. Otherwise, it'll just stay in the Alabama state courts, and they'll... Well, it will. It'll stay in the Alabama state courts, and they'll say, it's pretty clear, no gay marriage. What, can't you read? You know, so I've got to introduce a federal question. So what's my federal question? What's my federal argument? How is this a violation of my federal rights?
Right to make a contract.
Well, okay, you're getting close. Yeah, 14th Amendment, right? It says, no state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So, the 14th Amendment has basically been a gold mine. Well, I'm seriously, for anybody who feels like a state law is depriving them of their life, liberty, or property, and if they're being denied the equal protection of the laws, right? And so, especially when it's a liberty like gay marriage,
Yeah.
where you're less than a majority of the population. Are you paying attention?
Oh, come
Bad student. Anyway, if you feel like you're being denied certain fundamental freedoms and you're less than 50% of the population, then you can file a lawsuit under the 14th Amendment. Under the Due Process Clause, no state shall deprive any person of life, liberty, or property without due process of law, and the Equal Protection Clause, nor deny to any person within its jurisdiction the equal protection of the laws. Well, it has been a pleasure, class. We will continue recording and posting these. So this is the Judiciary lecture number 1. We'll have the Judiciary lecture number 2 soon. Have a great couple days, guys.